my name is Brittany Partridge, and I'm an attorney at Butler Kahn Law Firm. What is burden of proof? Burden of proof is the level of proof that the prosecution, plaintiff, and even sometimes the defendant must put on in court to prove either the elements of a crime or the elements of a claim or defense. And I'm going to talk to you about each of those burdens that we have here in Georgia. So in Georgia, we actually have 3 levels of burden. So there's beyond a reasonable doubt, clear and convincing, and preponderance of the evidence. So first, beyond a reasonable doubt. This is normally represented by scales where they start equal and the prosecution has put on sufficient evidence to bring the scale all the way down to the bottom. So we see that the scale is nearly touching the floor here in this example. And when we think about it, it's like the O.J. Simpson case. The famous line, if the glove don't fit, you must acquit. So the jury in that case found that it was reasonable to believe that whoever killed his victim must have fit that glove. That it was reasonable to believe that because O.J. Simpson's hand did not fit into that glove, he did not commit the murder. And that, in the criminal case, he was found not guilty. But we're going to talk more about how that's very different than the civil burden, preponderance of the evidence, in just a bit. So beyond a reasonable doubt, it's reserved for criminal cases, and beyond a reasonable doubt is exactly what it is. The doubt must be reasonable. I'm going to give another example here. In a DUI trial, say that the officer is testifying about what they found when they were on scene, that they were called to a car wreck after a witness had reported a car driving erratically, and that they saw a man driving the vehicle right before it crashed. And they saw a man exit the vehicle right after the crash. When the officer arrives on scene, he sees two men and a dog. Well, a reasonable doubt would be that one of the 2 men was driving the car. It would not be reasonable to believe that the dog was driving a car, or an unknown woman who was never on scene was driving the car. Those would not be reasonable doubts. And the way to go beyond the reasonable doubt there would be, say that the witness or one of the 2 men admitted that he was driving the vehicle. Well, that would be take away any reasonable doubt that one of the 2 men was driving the vehicle. So again, that is the criminal level of burden. So beyond a reasonable doubt, solely reserved for criminal cases. Next, we have clear and convincing. And this is a burden that is usually only for child-related claims. So in custody cases or parental termination of rights cases, you may hear clear and convincing, and it's oftentimes a judge is going to be the one finding whether or not there's clear and convincing evidence. So clear and convincing is also shown by these scales. So you can see it's higher off the ground than in the beyond a reasonable doubt, but it's still very tilted in favor of the plaintiff here. And so the plaintiff must prove what most people think of as about 75% carries 75% of their burden. So it's clear and convincing. You're about 75% sure that it is not in the child's best interest to be with this parent, or that you're about 75% sure that this parent is unable to do so, and their rights to parent should be terminated. Now, this is the second highest level, because your right to parent is actually a constitutional right. And so when you are taking away the right to parent your own child, it's actually one of your constitutional rights being taken away. So you can see here why the clear and convincing burden is reserved for such a serious case like that. Now, third is preponderance of the evidence. And this is probably the one that most people have not heard of, but it's the one that's often in court, and it's the only type of cases that we do here at Butler Kahn. So preponderance of the evidence is just tipping the scales in one's favor. So 50.1%, more likely than not. In a case, like a car wreck case, a civil case, you have to prove that it's more likely than not that the injuries were the cause of the collision, that the defendant caused the collision, just more likely than not. Now, oftentimes we hear jurors who may say, well, it could have been something else. Take, for example, a back injury. If we have a client who is testified that he had no back injuries, he never had pain, he had fallen once before, but he never saw a doctor, never got any treatment for it, and the fall was 20 years ago. But ever since this car wreck that happened last year, he has been in severe pain, he's been going to the doctor all the time, he's had to have surgery. it's more likely than not that the car wreck caused our client's back pain. Is it beyond a reasonable doubt that it caused the back pain? Well, that's not the level of burden that's carried in civil claims. So again, it's more likely than not. And I'm actually going to turn you back to the O.J. Simpson trial. So as we know, that criminal case, that beyond a reasonable doubt, O.J. Simpson was found not guilty. What some people don't know is that the family of the victim actually brought a civil case against O.J. Simpson, and they won. So in civil court, the jury found that it is more likely than not that O.J. Simpson killed his victim. But in the criminal case, he was found not guilty. And that has all to do with burden, the burden of proof. So because it was more likely than not that O.J. Simpson killed his victim, he was found liable. Because there was a reasonable doubt, arguably, that he killed his victim, he was found not guilty. I hope that this has answered any questions you may have about burden of proof here in Georgia.